Hi guys, welcome back to my channel Legal Awareness with Lady J. I know you must be wondering why I'm standing to talk today. I'm standing because today's topic is a very interesting topic that requires standing. This is actually my first time of standing to do a video. So today what are we looking at? We are looking at rape under the Nigerian law. The offense of rape has become a pandemic that is ravaging the world at large, and Nigeria is not an exception. In fact, rape now has become life threatening, and the number of rape cases reported on a daily basis, it's alarming and needs government attention and serious intervention. When we talk about rape, what do we mean by? According to section 357 of the Criminal Code Act, that is applicable in the southern part of Nigeria. When I talk about southern part of Nigeria, I'm talking of the non-Muslim states such as the state of Lagos, Rivers State, Bayelsa, and so on. Section 357 of the Criminal Code Act defines rape as having unlawful carnal knowledge of a woman or a girl without her consent, or with her consent if such consent is obtained by force, by threat of intimidation, or by fear of harm, or by means of fraudulent misrepresentation, and in the case of a married woman, by impersonating her husband. So the northern part of Nigeria is not also left out. We have rape provided for under section 282 of the Penal Code Act. The Penal Code is applicable in the northern part of Nigeria, the Muslim states such as Sokoto, Kano, and the rest of them. According to section 282 of the Penal Code, rape is defined thus that a man is said to have raped or to have committed the offense of rape, save in the case referred to in subsection 2, has sexual intercourse with a woman in the following circumstance: one, against her will; two, without her consent; three, with her consent when her consent was obtained by putting her in fear of death or hurt; or with her consent when the man know that he is not her husband and that her consent is given because the woman believe that he is the man to whom she is married to herself; or the last one is with or without her consent when she is under 14 years of age or of unsound mind. Rape is defined in the case of equal and states to mean forcible sexual intercourse with a girl or a woman without her giving consent to it. Here we are talking of carnal knowledge and sexual intercourse. What is carnal knowledge and sexual intercourse? Carnal knowledge and sexual intercourse are defined for the purpose of both the criminal code and the penal code as act of penetration by the penis. The definition exclude other sexual offences such as anal sexual intercourse or insertion of foreign object into a woman's vagina from the definition of rape. I know you may want to ask, can a husband rape his wife? Well, marital rape is unrecognized by Nigerian law because it is believed that consent to marriage it's tantamount to foreclosure of consent to a particular sexual intercourse. A man who inflicts extensive bodily harm on his wife can only be charged with the offense of assault and not rape. So we'll be hearing with her consent, without her consent. When we talk of consent, what do we mean by consent? In the case of Ganiyu Ogundikpe versus Samson Moriana, the court held that consent merely means to agree or permit someone to do something. So in general, consent means to give permission. Therefore, in the context of rape, consent is the permission, freedom, and capacity to choose to have sex or not to have sex. A woman who consents to intercourse at the beginning can actually withdraw her consent later on. And once a woman does not consent to the sexual intercourse, it is rape. And also, consent can also be incorrectly obtained. How? Consent is incorrectly obtained where it is gained by putting the woman in fear of death or hurt, bodily harm, or in the case of a married woman, by impersonating her husband just to have sex with her, or by use of intimidation also. In such an instant, if a woman consent based on these circumstances, consent is incorrectly obtained and the woman can actually bring an action against the man for the offense of rape. So I know you may want to ask, is rape exclusive to the male gender? Is it only the male that can commit rape? What about instances where men are raped? Well, our law does not identify or contemplate situations where a man could be raped, particularly as the criminal code describes penetration by as insertion into the vagina. A man does not have a vagina. Thus, it is widely believed that rape can only be committed by a man against a woman. But we know that the world is moving fast. Maybe tomorrow our criminal code might be amended, but the Violence Against Persons Prohibition Act also recognizes rape can be committed against anyone, be it man or woman. So now, what is the difference between rape and sexual assault? In rape, there is penetration of the female genitalia. That is, there is penetration of the female's vagina without consent of the female. But a sexual harassment or sexual assault, here there needs not to be sexual intercourse at all, as inappropriate touching, simply touching a woman inappropriately, may amount to sexual assault. So in sexual assault there is no penetration, while in rape there is penetration of the female genitalia, that is the vagina. So what is the punishment for rape, you may want to ask? The punishment for the offence of rape is life imprisonment, as provided for in section 358 of the Criminal Code Act. Also section 283 of the Penal Code Act, applicable in the north, also provide that whoever commits the offence of rape shall be punished with imprisonment for life or for any less term, and shall be liable to a fine as well. What are the things to show that rape has actually taken place, that somebody has raped somebody, a man has raped a woman? What are the things to show? To establish rape and the culpability of the accused person, the guilty act, that is the actus reus, as well as the intention, that is the mens rea, must be proved. In addition to this, the courts have consistently held that penetration with or without discharge is sufficient to prove rape, as the slightest penetration will be sufficient to constitute sexual intercourse. So it is immaterial that the rape of the victim was not completed. The act creates the offence of attempted rape and puts the punishment at, I think, 14 years imprisonment. Yes, 14 years imprisonment with or without caning. So whether you completed the act or not, once there is penetration, rape has taken place. So there are also other ingredients that must be proved by the prosecution, which are that the accused have sexual intercourse with the victim. Yes, like I said, there was sexual intercourse, that the act or the sexual intercourse was done without her consent, or with her consent, that the consent was obtained by force, by fraud, threat, intimidation, deceit, or impersonation of the victim's husband, and that the victim was not the wife of the accused, that the accused had the menstrual, that is the intention to have sexual intercourse with the victim without her consent, or that the accused acted recklessly, not caring whether the victim consented or not. Then the final one is that there was penetration. You know, there must be penetration. What is the punishment for false allegation of rape? We've had instances where people raise false alarm that they've been raped, and in the true sense of it, after everything, they found out that they were not raped. Of course, that person will not go scot-free. So, is there any punishment? Yes, there is. Section 8 of the Violence Against Persons Prohibition Act criminalizes false statement in this regard. So, with attendant punishment of 12 months imprisonment or a fine of 200,000. Also, where an accused is found innocent, such an accused person can also sue the victim, can prosecute the victim in a claim for damages, malicious prosecution, or defamation. Are there defenses to an accused person in the charge of rape? Yes, an accused person may rely on the following to exonerate himself or herself in a charge of rape. One, existence of consent, that there was consent. If the person can prove that the woman or the girl or the lady consented, it can exonerate him. Two, marriage, that they are married, because there is nothing like marital rape that is not recognized. If you can prove that that person is your lawfully wedded wife, it can exonerate the person. The next one is insanity, that the accused raped the person when he was insane. Like if you can prove that he was actually insane, not in his lucid moment, he was actually insane, like madness. When I say insanity, madness, if he was insane, they can also exonerate him. Are there defenses available to an accused person in the offense of rape? Yes, there are. And what are these defenses? An accused person may rely on the following to exonerate himself of charge of rape. One, existence of consent. If he can prove that the victim consented to the sexual intercourse, it will exonerate him. Number two is lack of penetration. If you can prove that there was no penetration, he did not penetrate, it can exonerate him the charge of rape. Then the third one is marriage. If you can prove that the victim, because there's nothing like marital rape, if you can prove that the victim is his lawfully wedded wife, it will exonerate him. The fourth and the final one is insanity. A person of unsound mind cannot be guilty of the offense of rape where the rape was committed while he was insane. So these are the defenses to the offense of rape. I'm sure we've learned one or two things, that having an unlawful carnal knowledge of a woman or a girl without her consent is rape, or with her consent if such consent was obtained by force, threat, intimidation, or in the case of a married woman by impersonating to be her husband, it is called rape. Thank you and see you in my next video. Bye.